I haven't either. So I got to go straight again. Go on. Be careful what you want. No, but we, you know, the whole system. He said send it back. So my step, the reason I had to take because I stopped handwriting. Because I don't want to wait.
There's so much I'll just search for his attorney. And that's why I found that his attorney strong. But there was a instance in Austin where this attorney went into court intentionally knowing that he was carrying a handgun. So he was arrested by the sheriff's discharge. I don't know what happened after that, but there's a
I never got
so in my chosen jurisdiction. I said basically that this is an issue of accountability. Anyway, so after we like one thing said was did he come there to kill somebody or did he still go his way? Or did he come there to intimidate somebody?
Bill you for the taxes, that's what we're doing. So they're not reporting the taxes, where you yeah, but we also go through the show now.
He was a friend of the friend. And when my friend died,
Somebody has a bad name for his action, it's
and he had approached me because other friends there.
it's either a little bit better or it's common sensible.
So he was very interested. He got into doing, and he had heard us from my friend Rod, who had died. Because of my friend Rod, he was right there, coin shop, jewelry, and stuff. He was a big into history. He was a big fan of my dad. My dad died from the when he was a teenager. He's my age. Small thing. So and he was really interested in this, and so okay, we're going to talk about it. So with my two friends that are sisters. And he went right in. And we're talking about it. He said, Ron and Chance were talking a lot about me. What I was doing, he wants to be part of it. And he presented himself, and I'd already been told by him very, very well.
So it's $1,000.
And yeah, 34, 33, 34 distribution centers, Walmart, Target, like that. And so then he had sold those, and he started retail store. It's a discount. So it's on the slide. It's in these big reviews. So anyway, he starts and I said, really, but make sure that you have to buy 36.
We know what he said.
And so, anyway, his wife made up some reasons about
Yeah.
so we had
Well,
to
it could be the house.
roll well after that house called me and he says, hey man, just I'm not supposed to
I hear something wrong with that speaker because it was making some noises. So hopefully everybody can hear you okay without the mic because it was making some noises. It could be there's.
I don't think it's that speaker.
It was making crackling noises.
Whatever.
And anyway, so
I can just go ahead. I can go ahead and put it over here.
use
this one.
That was.
I'm very close.
Yeah, it's real bad.
Anyway, so
He told me, I don't want to extreme solid. So he I always thought he was gonna get a. I could go with my.
I can't read it. Part of getting seminars.
Darren, you never let me borrow that truck you got.
They want
That white truck. Who's that? The one you just drive. Smart lady though. Smart lady though. Yeah. She's a mechanic. She works on.
Still lit it. And everything.
So he sent me some money. Anyway, he was working on the PCM, and I were going back to work on it until he said, yeah, this semester. So anyway, everything really was fun.
Believe that ready to get going?
I'm ready whenever you are.
Speaker.
Okay, what we're gonna do is we're going to I have a letter that I'm sending to the special agent in charge of the Pope's Federal Bureau of Investigation, military police in Dallas. And you'll find it kind of interesting. I go through and show how the Pope owns the Federal Bureau of Investigation. And so this is, I've already printed it out. I just have to get a notice of void judgment that the court, a certified copy of the notice of void judgment. So anyways, this is a standard notice and demand that I do. Let me just look here. Yep, it's showing here good. I'll make it so everybody can, if you can see it. I don't know if you can see it or not.
One more, can you enlarge it one more time?
There, I'm making it as big as I can, but I'm just gotta look on YouTube and make sure it's visible on YouTube, because this is live streaming to YouTube right now too. They're saying on YouTube the audio is messed up. It's probably echo. You can hear me from my computer. It could be echo from this speaker. So if you could, if you want to give me some feedback on if the audio sounds okay on YouTube. Anyways, I'm going to go ahead. I'll try not to make this too loud.
We should be getting better for him with the mic by the speaker.
Might be. Okay, so this is to R. Joseph Rothrock. Okay, this is the guy that was recently appointed by Donald Trump. The Pope's special agent, Dallas, the Pope's Federal Bureau of Investigation. It's from me. It's also sent to Pamela Bondi, private woman acting as the Pope's attorney with the rank of general, and is sent to Donald Trump and Nancy Larson, the Pope's acting United States attorney, and there's an Edward R. Martin Jr., who's the director of the Weaponization Working Group of the U.S. Department of Justice that Donald Trump has initiated, I guess you might say. So I'm going to send it to him too. So anyways, this is pretty standard. Every paragraph, so I'm going to, just to make this shorter, every paragraph starts off, you, R. Joseph Rothrock, the private man acting as special agent in charge, Dallas Field Office of the Pope's Federal Bureau of Investigation and Military Police, and subordinates and successors are noticed. Okay, so that's every paragraph's going to start that way. And so I don't say it every time. It's there, and I'll just go through what the paragraph says. I accept your oath of office. Okay, and at the very beginning, it says that I'm an inhabitant alive and well on the land of Texas, holder of the office of the people by right of blood that fails to be lost at sea and fails to be a minor estate without the Pope's owned and operated United States Inc. Do hereby notice you of the following. Okay, so then paragraph 2 says, equality under the law is paramount and mandatory by law. These are all standard. This is the same notice and demand, except I may make changes to it, but this, I've sent out literally thousands of these things. Now it's going, one thing you should notice, it's going by registered mail to the special agent in charge, but everybody else gets it by certified mail, because registered mail is presumed to have been served. Okay, the presumption is that they were served. It can be used for service. Okay, so we'll keep going. If you think or assume you're representing me, the heir of God, you're fired. That neither you nor any man or woman or any person is competent in dealing in any of my affairs, that I'm competent for dealing in all of my affairs. It's all about competence and incompetence, if you understand what's going on. They assault you with that minor estate. Any communication with me by you, your successors, your subordinates, shall be signed under penalty of perjury. That automatically makes it so they can't really communicate, because they have to lie. Anyways, the Pope's owned and operated minor estate with the names GlennWinningham Fern, Glenn W. Fern, and Fern GlennWinningham, or any derivative thereof, are common law copyrighted by me. Okay, there is such a thing as a common law copyright. And once I told them about it, it's in effect. Okay, you got to understand that. You'll notice that any violation of my copyright or making a legal determination for me, representing me, or communicating with me in any manner not under penalty of perjury would constitution to the acceptance of the fee of 10,000 1 troy ounce pieces of pure silver minimal, or 1,000,000 1 troy ounce pieces of pure silver if violated for the purpose of profit or gain. It's always for profit or gain. Or 10,000,000 1 troy ounce pieces of pure silver if violated for the purpose of profit or gain more than 3 times in a year for each and every violation. And I got to tell you that it easily gets into the hundreds of millions of dollars with this. I don't have to make it any worse. You'll notice that if you make a legal determination for me, you're practicing law without a license, in addition to the fees described herein. This is actually something that, what's that guy's name that came up with? Anyways. You'll notice that any violation as described in paragraph 8 above would constitute an agreement that I could seek relief from you, all of your corporate officers and directors, as well as your parent corporations and its officers and directors jointly, severally, and personally. So they're waiving their immunity. When they communicate with me, think about it. They're waiving any immunity they might have thought they had. You're noticed, as implied in your oaths, that pursuant to the Pope's Code of Law for the District of Columbia, now known as Title 18, United States Code, Section 1342, my proper name is GlennWinningham, House of Fern, and my proper postal address is General Post Office Zip Code Exempt, care of 6340 Lake Worth Boulevard, number 437, Fort Worth, Texas, without non-domestic mail, without the Pope's United States, Inc. And if it's not shown exactly like this in any communication with me, it's further agreed by you, your subordinates, and successors that you intend to be guilty of mail fraud. I massaged this one here for a long time, and I really like the wording on this one, I got to tell you. And I got to tell you that it's amazing how many times once I send this to somebody, they're very careful to make sure and send it to the right address. You're noticed as implied under your oaths that any communication to the Pope's minor estate, GlennWinningham Fern, Glenn W. Fern, or Fern Glenn Winningham Glenn, or any derivative thereof, in addition to the copyright violations, it's treason, breach of trust, sedition, perjury of oath, and other felony offenses, because you're criminally converting my name for the specific purpose of violating my God-given rights for your Vatican handlers, because a trust has no rights and is a thing, which is property, under the Commerce Clause, Article 1, Section 8, Clause 3. And capitis diminutio, meaning the diminishing of status through the use of capitalization in Roman law, diminishing or abridgment of personality, a loss of curtailment of a man's status, or the aggregate of legal attributes and qualifications. Capitis diminutio maxima, meaning the maximum loss of status through the use of capitalization. The highest or most comprehensive loss of status has occurred when a man's condition was changed from one of freedom to one of bondage. When he became a slave, it swept away all the rights of citizenship and all family rights. Because as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union, and this is National Mutual Insurance Company versus Tidewater Transfer Company, U.S. Supreme Court, 1948, and it says right here, in other words, Congress has exclusive legislative jurisdiction over citizens of Washington District of Columbia through their plenary power nationally, covers those citizens even when one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union, which is plenary jurisdiction under the Pope's canon Roman law. Plenary jurisdiction is a court's full and absolute power over the subject matter and the parties in the case. Plenary is full, complete, entire. Plenary is full, complete in the courts of admiralty and in the English ecclesiastical courts. Causes or suits in respect of different course of proceedings in each are termed plenary or summary. Plenary is a plenary power. Plenary authority is a complete and absolute power to take action on a particular issue with no limitations. It's derived from the Latin term plenus. It's a dictatorship. Plenary power, complete power of a particular area with no limitations. This offer is often used to describe the commerce power of Congress. Under the Commerce Clause, Article 1, Section 8, Clause 3, Congress is granted full power over interstate commerce. The court has found that states are not able to pass laws affecting interstate commerce without the permission of Congress. And that's taken from Legal Information Institute, which is Cornell Law School. To call it a quasi-contract with the objective of denying me my common law rights. There's no common law offenses against the United States, only those acts which Congress has forbidden with penalties for disobedience of its command or crimes. You're noticed that all living souls that are inhabiting the land known in Texas are American nationals because of common law. Anyone who's on the land has all the rights protected by common law, and they have more rights than one of the Pope's 14th Amendment U.S. citizens / minor estates, 31 CFR 363.6. You'll notice that the words person and whoever are used only for corporations and fictitious entities under the maxim for statutes of adjustum generis, because the word include is limiting and an individual is only the Pope's 31 CFR 363.6 minor estate sesticate trust fictitious entity. And this is Title 1, Section 1. The word person and whoever. The word person and whoever include corporations, companies, association, firm, partnership, joint societies, joint stock companies, as well as individuals. So that because of the maxim of law justum generis and definition section of statutes, entities listed are all the same kind of entities. Justum generis of the same class or nature in the construction of laws, wills, and other instruments. The justum generis rule is that where general words follow an enumeration of persons or things, the words of a particular and specific meaning, such general words are not to be construed in their widest extent, but are to be held as applying only to persons or things that are the same general kind or class as those specifically mentioned. For example, if a law refers to automobiles, trucks, tractors, motorcycles, and other motor-powered vehicles, vehicles would not include airplanes, since the list was land-based transportation. And that's taken from Black's Law Dictionary 4th edition. Here's another one from Black's Law Dictionary 8th edition. That gives a little bit different example. Says, for example, the phrase horses, cattle, sheep, pigs, goats, and any other type of farm animal would, with the general language or any other farm animal, the cite as seeming breadth, would probably be held to include only four-legged hoofed mammals, typically found on farms, and thus would exclude chickens. That in statute writing, the maxim of law says the word includes means only that which comes after it and excludes all else by its use. That's the inclusion of one is the exclusion of other. That's maxim of law, Bouvier's Law Dictionary, 1856 edition. For example, the rule that each citizen is entitled to vote implies that non-citizens are not entitled to vote. And in statute writing, the word includes is the word of limitation. Okay, this is Montello versus Salt. Include or participial form thereof is defined to comprise within, to hold, to contain, enclose, comprise, comprehend, embrace, involve. This is Black's Law Dictionary, 6th edition. Include, to confine within, to hold as an enclosure, take in, attain, shut up, contain, enclose, comprise, comprehend, embrace, involve. And they're citing this Previa Product Company versus Cameron, which means that under the Pope's Code of Law for the District of Columbia, now known as United States Code, Title 1, Section 1, The words person and whoever are only for the Pope's fictions of law. Right? You're noticed, as implied in your oaths, that the Pope's Code of Law for the District of Columbia, now known as Title 18 United States Code, Section 911, it's a felony for whoever to claim to be a minor estate U.S. citizen, 31 CFR 363.6, when it is known that they are not. And even though I can prove that I'm not a whoever, I do not bear false witness there. I cannot claim to be a minor estate U.S. citizen, 31 CFR 363.6, when I know I'm not. And for anyone else to claim, this is false personation again, okay? For anyone else to claim I'm a minor estate U.S. citizen, 31 CFR 363.6, is also false personation. And whoever falsely and willfully represents himself to be a citizen of the United States shall be fined under this title or imprisoned not more than 3 years of both. But this section is called false personation. And it's your job to investigate the felons that are falsely accusing me of being a U.S. citizen minor estate in violation of the Pope's 18 U.S.C. 911 false personation. Was someone going to say something
I have a
there?
question, Glenn. So the false personation is basically you're committing a felony impersonating a corporation, right?
Well,
Or they're trying to make you commit a felony by impersonating.
yeah, they're accusing me of being that's right. They're accusing me as false personation as they're saying that I'm this U.S. citizen when they're supposed to know I'm not. And I haven't volunteered for it some way.
Right.
You're noticed that the Pope's minor estate, U.S. citizen, 31 CFR 363.6 is a person. That's 14th Amendment. You're noticed that the Pope's U.S. citizen is a fiction of law. This is ex parte Frank Knowles. It might be correctly said there is no such thing as a citizen of the United States. A citizen of any one of the states of the Union is held to be and called a citizen of the United States, although technically and abstractly there is no such thing. And then this is Public Law 100-418, August 23rd, 1988. As used in this section, the term United States business means a United States citizen, so it's a corporation. That's what it said. Corporation, partnership, or other association created under the laws of the United States or any state, including a District of Columbia or any Commonwealth, territory, or possession of the United States, a foreign corporation. And fictions of law were invented by the Roman praetors under Roman law for the Pope's ecclesiastical city-state that is now the Vatican under the pretense of doing equity. And this is Bouvier's Law Dictionary, 1856 edition. And says fictions of law were invented by the Roman praetors who, not possessing the power to abrogate the law, were nevertheless willing to derogate from it under the pretense of doing equity. Fiction is the resource of weakness, which is in order to obtain its object assumes a fact that is known to be contrary to truth. When the legislator decides to accomplish his object, he need not feign, he commands. Fictions of law owe their origins to the legislative usurpations of the bench. And that's Bouvier's Law Dictionary again. And fictions of law owe their origins to the legislative usurpations of the bench, which means the fake judge is a legislator. When dealing with fictions of law, which means the fake judge's legislative act is a bill of attainder, because a bill of attainder is a legislative act that applied to named individuals to inflict punishment without a judicial trial, which is taken from this United States versus Brown. Bill of attainder, legislative act, it's basically what I just said. A bill of attainder, this is Black's 8th special legislative act prescribing punishment without trial for a specific person or group. Bill of attainder, those similar pill of pains and penalties, those similar to a bill of attainder, prescribes punishment less severe than capital punishment. So a bill of attainder is the death penalty. Because judges only hold office during good behavior, that's Article 3, Section 1. And judges in bad behavior engage in fraud upon the court. And the Pope's fiction of law, U.S. citizen, as defined by the so-called 14th Amendment, has to be completely subject to the jurisdiction of the United States, and therefore is not one of we the people, state citizens, but is the Pope's sesticate trust, minor estate, or other fictitious entity. And here's some court cases that the persons declared to be citizens are all persons born or naturalized in the United States and subject to the jurisdiction thereof. The evident meaning of these last words are not merely subject in some respect or degree to the jurisdiction of the United States, but completely subject. That's Elk versus Wilkins, U.S. Supreme Court, 1884. It is evidence that they, U.S. citizens, have not the political rights that are vested in citizens of the states. They're not constituents of any community in which is vested any sovereign power of government. Their position partakes more of the character of subjects rather than citizens. They're subjects of the law of the United States and have no voice in its management. If they're allowed to make laws, the validity of these laws is derived from the sanction of a government in which they're not represented. Mere citizenship they may have, but the political rights of citizens they cannot enjoy. And that's People versus De La Guerra, California. The term citizen in the United States is analogous to the term subject in the common law. Somebody else want to talk here?
Oh, it's Leslie. She couldn't hear on the Zoom.
Well, we're not on Zoom right now.
Oh, okay.
And the Pope's U.S. citizen fiction of law has no rights. Therefore, U.S. citizens residing in one of the states of the Union are classified as property and franchises of the federal government as an individual entity. In our opinion, it's not the intent of the legislature to restrict the operation of the statute to only those who are subjects of the United States. Upon the other hand, the 14th Amendment on the subject of citizenship declares that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Here is the limitation to a person born or naturalized in the United States, which is not extended to persons born in any place subject to their jurisdiction. A U.S. citizen, upon leaving the District of Columbia, becomes involved in interstate commerce. As a resident, does not have the common law right to travel of a citizen of one of the several states. The right to trial by jury in civil cases guaranteed by the 7th Amendment, and the right to bear arms guaranteed by the 2nd Amendment have been distinctly held not to be privileged immunities of citizens of the United States guaranteed by the 14th Amendment against abridgment by the states. And in effect, the same decision was made in respect to the guarantees against prosecution, except by indictment of a grand jury. That's why you see all these fake indictments contained in the 5th Amendment, and in respect to the right to be confronted with witnesses contained in the 6th Amendment. The privileges and immunities of citizens of the United States do not necessarily include all the rights protected by the first 8 amendments to the federal Constitution against the powers of the federal government. The 14th Amendment referred to slavery. Consequently, the only persons embraced by its provisions for which the Congress was authorized to legislate in the manner were those then in slavery. All citizens of the Pope's United States shall have the same right in every state and territory as is enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, and convey real or personal property. And that's current 42 United States Code, Section 1982. Because the Pope's U.S. citizens are subject and may also be taxed, Slater's protestation to the effect that he derives no benefit from the United States government have no bearing on his legal obligation to pay income tax. Unless the defendant can establish that he's not a citizen of the United States, the IRS possesses authority to attempt to determine his federal tax liability. And a taxpayer is a sesticate trust that belongs to what is now your Vatican handlers. Every taxpayer's sesticate trust having sufficient interest in preventing abuse of the trust to be recognized in the field of this court's prerogative jurisdiction. Therefore, a Social Security number is a number for the Pope's sesticate trust U.S. citizen, minor estate, and has no rights except those granted by Congress. The only absolute and unqualified right of a United States citizen is the residence within the territory and boundaries of the United States. After the adoption of the 14th Amendment, a bill which became the first Civil Rights Act was introduced in the 39th Congress, the major purpose of which was to secure the recently freed Negroes, all the civil rights secured to white men. None other than citizens of the United States were in the provisions of the act. And the Pope's fiction of law, U.S. citizen has no right to the custody of their children. Civil rights under the 14th Amendment are for federal citizens, not state citizens. Federal citizens as parents have no right to the custody of their infant children except subject to the paramount right of the state. And the Pope's so-called 14th Amendment converted citizenship into the opposite of what the Founding Fathers intended for what is now your Vatican handlers. And while the 14th Amendment does not create a national citizenship, it has the effect of making that citizenship paramount and dominant instead of derivative and dependent. So it turned it into the opposite of what was intended under the Constitution. The term resident and citizen of the United States is distinguished from a citizen of one of the several states in that the former is a special class of citizen created by Congress. You'll notice that your attorneys are all private bar guild members because BAR is an acronym, stands for British Accredited Regency. This is Black's Law Dictionary 8th edition. A regency, the office or jurisdiction of a region or body of regents. Because all private bar guild members are appointed by the Pope's Inns of Court. Inns of Court is Black's Law Dictionary 5th edition, certain private unincorporated associations in the nature of collegiate houses located in London and invested with the exclusive privilege of calling men to the bar, which is located in the Pope's owned and operated dependent city-state of the City of London, called the Kingdoms of England and Ireland, now known as United Kingdom, and the Crown since the concessions of England to the Pope, 1213. And this is concessions of England. We will establish a perpetual obligation and concession that from the proper special revenues of the aforesaid kingdoms for all service and customs which we ought to render for them saving in all things the penny of St. Peter, the Roman Church shall receive yearly 1,000 marks sterling, namely at the feast of St. Michael 500 marks and at Easter 500 marks, 700 for the Kingdom of England, 300 for the Kingdom of Ireland, which is a walled-in area in downtown London that was never conquered by William the Conqueror in 1066, because King John gave the kingdoms of England and Ireland to the Pope and agreed to rent them back for 1,000 marks sterling per year. And this is Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of Pope. And not long after this, by general excommunication of the king and people for several years, because they would not suffer an archbishop to be imposed on them, King John was reduced to such straits that he surrendered his kingdoms to Pope Innocent III to receive them again and hold them of him under the rent of 1,000 marks. Which means all private bar guild members are foreign agents of the Pope and priests of Baal, which is why they're here under the Pope's civil laws of Congress, the foundation of the Federal Bar Association, Code of Law of the District of Columbia, now known as Title 35, United States Code 70501 through 70512, claiming immunity under the Pope's International Organization Immunity Act of 1945. And the Pope's crown has erected a statue to Abraham Lincoln in the Pope's city of London, probably because he facilitated the disappearance of the true Article 13 Amendment, that's what this is. If any citizen of the United States shall accept, claim, receive, retain any title of nobility or honor, or shall, without the consent of Congress, accept and retain any present pension, office, emolument of any kind whatever from any emperor, king, prince, or foreign power, such person shall cease to be a citizen of the United States and shall be incapable of holding any office of trust or profit under them or either of them. And that's Article 13, an amendment taken from the Constitution of the United States, taken from a certified copy of an 1819 U.S. Constitution in Virginia statutes, which would have prevented Lincoln and the rest of the Pope's private bar guild priests, Baal priests, from holding any office of trust which requires an oath of office in any federal or state government. You'll notice that the Pope's owned and operated dependent city-state in the City of London, called the Crown, created the Cestui Que Vie Act of 1666.
Yet still it was found difficult to set bounds to ecclesiastical ingenuity. For when they were driven out of all their former holds, they devised a new method of conveyance, which lands were granted not to themselves directly, but to nominal fees to the use of the religious houses, use being usufruct, thus distinguishing between the possession and the use, and receiving the actual profits, while the seed and the land remained in a nominal fee, who was held by the courts of equity, then under the direction of the clergy, that's the Roman cult, folks, to be bound in conscience to account to assesticate use for the rents and emoluments of the estate. That's taxes. And it is to these inventions that our practitioners are indebted for the introduction of uses and trusts, the foundation of modern conveyancing. And that's from Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of mortmain, which is what precipitated the War of Independence, as evidenced by the causes and necessities for taking up arms issued by the Continental Congress in 1775. Statutes have been passed extending courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, instead thereof to publish and order the use, the exercise of law martial, and for altering fundamentally the form of government established by charter, we saw the misery to which such dictatorship would reduce us. And the organic law of the Declaration of Independence shows it was listed as reasons for the Declaration of Independence from the Pope's owned and operated tyrant, the Crown of England. He's conspired with others. Well, I won't read that. I go through some of it here. Because when they say he's combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws, it is talking about the Pope's canon Roman law, which is also why millions of people were fleeing Europe at that time, because of the Pope's tyranny there. And tyranny, this is John Locke, Two Treatises of Government, Book 2, Chapter 18, Section 199 and 201. Tyranny is the exercise of power beyond right, which nobody can have a right to. And this is making use of power anyone has in his hands, not for the good of those who are under it, but for his own private separate advantage. When the government, however entitled, makes not the law, but his will, the rule, and his commands and actions are not directed to the preservation of the properties of the people, but to the satisfaction of his own ambition, revenge, covetousness, or any other irregular passion. 'Tis a mistake to think this fault only in monarchies. Other forms of government are liable to it as well as that. For wherever the power that's put in the hands of the government of the people and the preservation of their properties is applied to other ends and made use of to impoverish, harass, or subdue them to the arbitrary and irregular commands of those who have it, there it presently becomes tyranny, whether those that use it are one or many. With the Pope's Spanish Inquisition, and the Inquisition is one way of proceeding in ecclesiastical courts. I'm sure we've all heard about the Spanish Inquisition. And the Pope's other inquisitions and oppressions. The use of information has a long history. For example, in the reign of Henry VII, a very impressive use was made of them for something more than a century, so as to continually harass and shamefully enrich the Pope's crown. And that's taken from Blackstone's Commentaries on the Laws of England. Courts ecclesiastical. Spiritual courts, those courts which are held by the king's authority as supreme governor of the church for matters which chiefly concern religion. And laws and constitutions whereby the Church of England is governed are diverse and memorial customs and other provincial constitutions, and the canons made in convocations, especially those in the year 1603. Much oppression having been exercised through the channel of these courts. It's the same stuff that's going on now, on persons charged with trifling offenses within their spiritual jurisdiction. And that's Tomlin's Law Dictionary, 1835 edition, volume 1. It's exactly the same stuff that's going on right now. Which is why my ancestors made the very first article and amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And the Pope's canon Roman law, sesticate usufruct, was brought into America first by orchestrating the southern states walking out of Congress, and Congress failing to have a quorum and failing to be able to conduct business, to precipitate the Civil War, and Lincoln the Pope's private bar guild member, ordering Congress to convene under the Pope's executive authority with Executive Order Number 1 on the 15th of April, 1861 at 1258. I gotta silence this thing. And evidenced by the fact that the popes owned and operated Queen Victoria was giving aid and comfort to the Confederate States of America in many ways, one of which is when she sent a fleet of ships to attack Washington, D.C. and San Francisco, and the Russians sent fleets to blockade them. And then after the war, with the Pope's 1871 Municipal Corporation at 16 Stat 419, civil law, Roman civil law, convertible phrases meaning the same system of jurisprudence, the rule of action which every particular nation, commonwealth, or city established peculiarly for itself, more properly called municipal law. And then the Code of Law for the District of Columbia, 1901. The legal estate to be the Sisticae use. Okay, that's where they're bringing up that Sisticae V Act of 1666. They're bringing it into America. And the Pope's minor estate, Sisticae usufruct, now codified at 31 CFR 363.6, and are unconstitutional because municipal law was originally municipia, which is the law of the dependent papal ecclesiastical city-states. Civil or municipal law is the law of every sovereign kingdom is appropriated to itself. The appellation of municipal was originally confined to the laws of the municipia, or dependent states. And that's taken from Encyclopedia Britannica, or New Dictionary of Arts and Sciences, 1771. Roman or papal states stretch across the central part of the Italian peninsula in an oblique direction from the Adriatic to the Mediterranean, and between Tuscany, Modena, and Lombardy on the northwest, and Naples in the southeast. The area is 17,822 square miles. Population in 1833 is 2,742,000. Capital, Rome. Population 153,000. Government and elective monarchy. The Pope, for the time being, the absolute sovereign, with a consulting assembly of cardinals. And that's Waterston Encyclopedia of Commerce and Mercantile Law, 1863, page 582. Rome is the capital of the Pope's territories of Italy and anciently the Milrus of the Roman Empire, and was also called canon law. The civil or Roman and canon law, though they're perhaps not deemed proper parts of our written law, so that it's actually also called canon law, and I'm not going to skip some of this. If anybody wants the word file, I'll send it to them. There's no way I'm going to get through this. Why did I even try them?
Well, we can continue next week. It's just that we have scheduled, plan for the.
Yeah, I think you should just forget about scheduling me from now on.
Why?
And the Pope's ecclesiastical city-states were annexed to the Kingdom of Italy in 1870, a year before the 1871 Municipal Corporation enacted by Congress. The formerly Republican leader in southern Italy, Giuseppe Garibaldi, made common cause with the House of Savoy to overthrow the Kingdom of the Two Sicilies, and the people voted in a plebiscite to join Sardinia to form the Kingdom of Italy in 1861. The Papal States and the city of Rome were annexed to the kingdom in 1870, completing the unification of Italy, and are now called Vatican City and the Holy See, and it continues to this day. The sovereignty and exclusive jurisdiction of the Vatican City, which Italy recognizes as appertaining to the Holy See, forbid any intervention therein as part of the Italian government, on the part of the Italian government, or any authority other than the Holy See shall be there acknowledged. And that's the Lateran Pact, Article 4, 1929. And I don't know if you remember that Pope Benedict, he was convicted by the International Common Law Court of rape and murder and a bunch of things, and the Italian police were going to arrest him, and that's why he resigned, and he stayed in the Vatican for the rest of his life. And so I guess we're about done now. Anyways, we didn't get anywhere. We're on page 12 of 34. So anyways, so you have no idea what this thing does or anything. It goes through a bunch of things. Yeah, don't bother scheduling me anymore. I mean, I'll do these at home. I'll do them on YouTube. It's no big deal. Anyways, everybody on YouTube, like it's been like not even an hour. Anyways.